Hi, this is Manjri Singh from Law School 101 and this is another video in the Legal Aptitude series brought to you by Law School 101 for CLAT aspirants. In this video, we will be covering law of contracts. We will be covering the following topics in the order listed: consideration and then valid, voidable and void contracts, then enforceability and barred contracts, followed by CLAT 2017 questions, ILEAT 2017 questions, CLAT 2016 questions, ILEAT 2016 questions. Important case examples and legal awareness information has also been given where applicable. Let's begin with consideration. Section 2 of the Indian Contract Act defines consideration. It is as follows: when, at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing something, such act or abstinence or promise is called a consideration for the promise. Consideration is the price of the promise. It is the act or abstinence in which is given in return of an offer. Consideration can be an act, an abstinence, or a promise, or very simply a monetary price. It may be delivered in the past, present, or the future. An agreement without consideration becomes void. Consideration needs to have value in the eyes of law. It needs to be sufficient, not adequate. Consideration should not be worthless, however, and it can also not be physically or legally impossible, uncertain or not specific, or illusory, or it ceases to have value in the eyes of law. The next important points to note are: number 1. Consideration may come from a third party that need not be one of the parties in the contract. In the case of Chinnaya versus Ramaya, an old lady transfers property to her daughter in consideration for her paying an annuity to the old lady's sister. The daughter initially pays the annuity, however, she stops by claiming the old lady's sister never gave her any consideration and hence she was not obliged to the contract. It was held that the mother had given the consideration and that it made the contract valid. Number 2. A promise to pay a subscription becomes enforceable if definitive steps are taken in furtherance of the object of the subscription. If the other party acts on the promise, it becomes an enforceable contract. In the case of Kedarnath versus Gori Muhammad, on the basis of promised subscription of the defendant, the plaintiff hired a contractor to construct a town hall. The defendant was held liable to pay as the plaintiff had acted on the promise. In another case, no follow-up action had been taken by the plaintiff and the defendant was not held liable to pay. The third point is, acts done voluntarily at the desire of a party does not become consideration for a valid contract. However, the voluntary act in the past can be decided as the consideration if the party so decides to compensate for it. For example, if A rescues B's son voluntarily, he cannot claim any compensation. However, B may choose to create a contract with A and pay him a certain amount as compensation, with the consideration being the rescue that was voluntarily undertaken by A. There are exceptions to the rule that requires consideration for a valid contract. These exceptions are given in Section 25 of the Act. They are as follows. Number 1. If it is expressed in writing and registered under the law for the time being in force and is made on account of natural love and affection between the parties standing in near relation to each other. Second, if it is a promise to compensate a person who has already voluntarily done something for the promisor. Number 3, when there is an agreement made in writing and signed by the debtor or by his authorized agent to pay a debt barred by the law of limitation. A time-barred debt is a debt that has become unenforceable because it has been due for over the period of limitation. The fourth is a gift, donation, charity contracts are valid despite no consideration. Important situations and case law will now be discussed. The first is the important case of Venkataswamy versus Rangaswamy. An older brother, on account of natural love and affection, promised to pay the debts of his younger brother. The agreement was in writing and registered. It was held that the older brother was liable to the creditors. The second situation is, if A finds B's purse and gives it to him, and B promises to give A rupees 50, this is a contract. The third situation is, A supports B's infant son. B promises to pay A's expenses in so doing. This is a contract. The fourth is A owes B rupees 1000, but the debt is barred by the Limitation Act. A signs a written promise to pay B rupees 500 on account of the debt. This is a contract. The fifth situation is A, for natural love and affection, promises to give his son B 1000 rupees. A puts his promise to B into writing and registers it. This is a contract. The sixth one is A promises for no consideration to give to B rupees 1000. This is a void agreement. All of these situations have been taken from the Indian Contract Act. These situations are specifically mentioned in the Act. Now we move on to valid, void, and voidable contracts. A valid contract is a contract that is legally enforceable. A voidable contract is a contract that can be enforced at the will of a particular party. A voidable contract arises due to coercion, undue influence, fraud, or misrepresentation. It can be enforced by the party whose consent was obtained by any of the above listed means. These cases may also be void as per the circumstance. A void contract is a contract that cannot be legally enforced. Void ab initio means void since the inception of the contract. Void means valid contract becoming void due to circumstance, for example, impossibility of performance. The law treats a void contract as if it had never been formed. Under void contract, no remedy exists for either party. This is the basic difference between a void and voidable contract. In a voidable contract, it is enforceable at the will of one party. In a void contract, it is not enforceable by either party. The difference between void ab initio and void is, void ab initio means that the contract was never valid. Void means a valid contract later becoming void for some reason due to circumstance. A contract is void if, number one, the subject matter is legal, or one party is mentally unsound at the time of making the contract, or agreements that require performing something impossible or depends on an impossible event happening are void, or agreements in restraint of marriage, wagering agreements, agreements with a minor, agreements to not institute legal proceedings, agreements without consideration, and finally agreements that are against public policy because they are too unfair or are generally opposed to public policy. If a person agrees to marry or not to marry a particular individual, such an agreement is void ab initio. If a person agrees to not start the same trade in the same locality, the contract is void ab initio. No money can be recovered if paid as consideration for such contracts. If a person agrees to not start legal proceedings against another in a dispute and is given consideration, he or she is still free to sue and enter legal proceedings, as this contract is also void ab initio. Uncertain agreements are also void. For example, if a vegetable seller agrees to sell 1 kilogram without specifying the vegetable, the contract is void. If the vegetable seller, however, only sells potatoes, then the contract is valid. Bets, wagering agreements, and agreements to do the impossible are also void. Now let's list some important cases and situations. An important case to note is Mohiri Baibi versus Dharmodas Ghose. A miner received money from a lender by mortgaging his house. The Privy Council held that the money lender could not get his money back as there was no contract to begin with. The second situation is A agrees to sell B a specific cargo of goods supposed to be on its way from England to Bombay. It turns out that before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. Neither party was aware of the facts. This agreement is void. The third situation is A agrees to buy from B a certain horse. It turns out that the horse was dead at the time of the bargain, though neither party was aware of the fact. This agreement is void. The fourth situation is A, being entitled to an estate for the life of B, agrees to sell it to C. B was dead at the time of the agreement, but both parties were ignorant of the fact. This agreement is void. The fifth situation is A promises to pay B 1000 rupees at the end of 6 months if C, who owes that sum to B, fails to pay it. B promises to grant time to C accordingly. Here, the promise of each party is the consideration for the promise of the other party, and they are lawful considerations. Situation 6. A promises for a certain sum paid to him by B to make good to B the value of his ship if it is wrecked on a certain voyage. Here A's promise is the consideration for B's payment and B's payment is the consideration for A's promise, and these are lawful considerations. In situation 7, A, B and C enter into an agreement for the division among them of gains acquired or to be acquired by them by fraud. This agreement is void as its object is unlawful. The eighth situation is A, intending to deceive B, falsely represents that 500 mounds of indigo are made annually at A's factory and thereby induces B to buy the factory. The contract is voidable at the option of B. The ninth situation is A, by a misrepresentation, leads B to erroneously believe that 500 mounds of indigo are made annually at A's factory. B examines the accounts of the factory which show that only 400 mounds of indigo have been made. After this, B buys the factory. The contract is not voidable on account of A's misrepresentation because B has chosen to enforce it. Situation 10 is A fraudulently informs B that A's estate is free from encumbrance. B, therefore, buys the estate. The estate is subject to a mortgage. B may either avoid the contract or may insist on its being carried out and the mortgage debt redeemed. Situation 11. B, having discovered a vein of ore on the estate of A, adopts means to conceal and does conceal the existence of the ore from A. Through A's ignorance, B is enabled to buy the estate at an undervalue. The contract is voidable at the option of A. Situation 12. A is entitled to succeed to an estate at the death of B. B dies. C, having received intelligence of B's death, prevents the intelligence reaching A and thus induces A to sell him his interest in the estate. The sale is avoidable at the option of A. A, intending to deceive B, falsely represents that 500 mounds of indigo are made annually at A's factory, thereby induces B to buy the factory. The contract is voidable at the option of B. Now, we will begin discussing questions. Keep in mind the concepts discussed so far. Also ensure you will apply only the principles strictly. Pay attention to the explanations. You may choose to turn on the captions of this video to take a better look at the explanations. Let's begin. Let's begin from CLAT 2017 questions. Principle. Every agreement by which any party is restricted absolutely from enforcing his right in respect of any contract by the usual legal proceedings in the ordinary tribunals is void to that extent. The law also provides that nobody can confer jurisdiction to a civil court by an agreement between parties. Facts. A and B entered into a valid contract for rendering a certain service. A clause in the contract was that in case of any dispute arose out of the contract, it shall be referred for arbitration only. Is the contract valid? The answer options are: number 1, arbitration is also a valid dispute settlement machinery recognized by law and hence the entire contract is valid. Option 2, the parties were trying to confer jurisdiction to some authority to decide a dispute and hence the clause would be invalid. Option 3, arbitrator cannot be termed as an ordinary tribunal, hence the agreement is void and would be unenforceable. Option 4, the contract is valid but the clause regarding arbitration is void. The correct answer choice is option 1. The explanation is given in the answer choice. Arbitration does not mean restraining from legal proceedings, as arbitration itself is a legally recognized dispute settlement mechanism. Arbitration is also not conferring jurisdiction to a civil court and hence the contract is entirely valid. The next question. Principle. When a person who has made a promise to another person to do something does not fulfill his promise, the other person becomes entitled to receive from the person who did not fulfill his promise compensation in the form of money. The facts. X made a promise to Y to repair his car engine. Y made the payment for the repair. After the repair, Y went for a drive in the same car. While driving the car, Y met with an accident due to the bursting of a tire. The answer options are: number 1, Y will be entitled to receive compensation from X in the form of money. Number 2, X will not be entitled to receive compensation. Number 3, X will be entitled to receive compensation from Y in the form of money. And number 4, Y will not be entitled to receive compensation from X. The correct answer choice is 4. The payment was made for the repair and the repair has been made by X as per the fact situation. The contract has concluded here as the promise has been fulfilled and X owes no further obligation to Y. Therefore, Y is not entitled to receive compensation for what happens after the repair. The next question. Principle. Every agreement of which the object or consideration is opposed to public policy is void. An agreement which has the tendency to injure public interest or public welfare is one against public policy. What constitutes an injury to public interest or public welfare would depend upon the times and circumstances. Facts. A promises to obtain for B an employment in the public service and B promises to pay 5 lakh rupees to A. The answer options. Number 1. The agreement is void as the object in consideration for it is opposed to public policy. Number 2. The agreement is void because 5 lakh rupees is excessive. Number 3. The agreement is valid as it is with consideration for public service. And number 4. The agreement is valid as it is a contract between two parties with their free consent. The correct option is 1. Employment in the public services cannot be promised and doing so is corruption, bribery and opposed to public policy, also considering the time and circumstance. Next question. The principle. According to law, a person is deemed to have attained the age of majority when he completes the age of 18 years, except in the case of a person where a guardian of a minor's person or property has been appointed under the Guardians and Wards Act 1890 or where the superintendence of a minor's property is assumed by a court of wards. Indian law expressly forbids a minor from entering into a contract. Hence, any contract entered into a minor is void ab initio regardless of whether the other party was aware of his minority or not. Further, though a minor is not competent to contract, nothing in the Contract Act prevents him from making the other party bound to the minor. Facts. Lal executed a promissory note in favor of Gurudutt, aged 16 years, stating that he would pay Gurudutt a sum of 2 lakh rupees when he attains the age of majority. On attaining the age of 18, Gurudutt demanded the amount from Lal, who refused to pay. Gurudutt wants to take legal action against Lal. Identify the most appropriate legal position from the following. The options are, number 1, a promissory note duly executed in favor of a minor is not void and cannot be sued upon by him because he is thought to be incompetent to contract, but he may yet accept a benefit. Number 2, Gurudutt should not have entered into a contract with Lal when he was a minor. Option 3, Lal was not aware of the fact that Gurudutt was a minor. And option 4, Lal argues that as per the Guardians and Wards Act of 1890, Gurudutt can claim the money only after he attains the age of 21. The correct answer option is number 1. The key is to understand the principle given first. The principle explains that any contractual obligation of a minor cannot exist, but an obligation to the minor is enforceable. In this case, the promissory note is an obligation of Lal to Gurudutt. Therefore, Gurudutt's being a minor is irrelevant to the performance of Lal's obligation. Principle. A contract would be invalid and unlawful if the contract is for an immoral or illegal purpose. Facts. P was a young and helpless widow living on the pavement. R, a neighbor, gave her a house registered in her name on the condition that she should allow R to keep his smuggled goods and drugs in her house. After the registration was done, according to the condition in the contract, R's agents wanted to keep some packets in her house, but she refused. R told her the condition under which the house was given to her. She still refused. Is P justified in her action? And your answer options are, number 1, P is not justified as she did not have the right to deny R's request. Number 2, as R was making the contract for illegal activities, P's stand is valid in law. Number 3, R can take back the house for cancelling the transfer deed. And number 4, P is right as she did not like smuggled goods to be kept in her house. The correct answer option is 2. P is justified in her action as the contract is void because it is for an unlawful purpose. Therefore, R has no recourse in law. Now we move on to ILEAT 2017 questions. The first question is legal principle. Contract is an agreement freely entered into between the parties, but when consent to an agreement is obtained by undue influence, the contract is voidable at the option of the party whose consent was so obtained. Now the factual situation. Pragya had been working for a businessman since the age of 18, working for a range of Anurag's businesses. In 2000, aged 21, Pragya purchased a flat. In 2005, Mr. Anurag's business was facing financial difficulties and he asked Pragya to offer up her flat as security against an overdraft facility for the business. In July of that year, the bank solicitors wrote to Pragya advising her to take independent legal advice before putting up her property as security for the debt. The bank also notified Pragya that the guarantee was unlimited in both time and financial amount. Having discussed the arrangement with Anurag, Pragya was unaware of the extent of the borrowing but was reassured that her mortgage would not be called upon and that his own properties were listed as securities that would be looked to first. A charge was executed over Pragya's property in August 2005. In August 2009, Mr. Anurag's business went into liquidation and the bank formally demanded rupees 60,24,912 from Pragya. Pragya raised the defense of undue influence, stating that Mr. Anurag had induced her to enter into the agreement and that the bank had full knowledge or notice of this undue influence, which should set aside the bank's right to enforce a debt recovery against Pragya. Bank is contending that there is no undue influence. The question is, number 1, whether the consent to offer the flat as financial security was obtained through undue influence. Your answer options are, number 1, no, because Pragya was not forced by Anurag to offer her flat as a security. B, no, because Pragya was an educated and adult employee of Anurag and she knew what she was doing. Option C, yes, an employer-employee relationship was capable of developing into such a relationship of undue influence. There was no benefit to Pragya in the agreement. The lack of benefit to one party was evidence enough. And option D, no, an employer-employee relationship is not capable of developing into a relationship for undue influence. The correct answer choice is option C. This question is a little tough. Let's break it down. We know that if there is undue influence, the contract is not valid and hence the bank cannot take action against Pragya. Thus, the answer rests upon whether there was undue influence on Pragya. The facts do not make clear definitely the mind state of Pragya. Therefore, we need to interpret through the situation and circumstance. Anurag is the employer of Pragya. Also evident is that Pragya has received no benefit from the contract. It should be noted that she was not even aware of the amount. The only alternative would be her declining Anurag, which would have jeopardized her job. Therefore, we can conclude that there was undue influence. You can also do this by eliminating the answer options. The next question to the same factual situation is, irrespective of your answer to the previous question, assume it is a case of undue influence. Decide whether the bank has done enough to allay concerns of undue influence. Option A. The bank has not made all reasonable steps to allay themselves of the concerns of undue influence. The fact that, on advice from the bank, the defendant did not seek independent advice should have been taken as confirmation of undue influence. B. Yes, the bank advised Pragya that she should take independent legal advice before putting up her property as security for the debt. Option C, Pragya has a duty to be aware of the consequences of her act. And option D, the bank has done enough to notify. The explanation is that the correct answer choice is option A. The above circumstances from which we derived undue influence were also evident to the bank. The bank only sent notification and did not pay attention to the fact that Pragya did not seek independent advice despite the bank's warning. Also, considering the amount of the overdraft and the financial position of the company, the bank did not do enough. Now we move on to questions from CLAT 2016. The principle. Number 1, wagering agreements are void. Number 2, collateral agreements to wagering contracts are valid. Facts. XYZ Bank lends 40,000 rupees to Sabu in order to enable him to award as prize to Randeep, who is the winner of horse race. Later, Sabu refuses to pay the prize amount, stating that the horse racing is a wagering agreement. Can XYZ Bank recover the money from Sabu? The answer options are number 1, yes, it is only a collateral agreement to horse racing and therefore the bank can recover the money from Sabu. Number 2, horse racing is illegal and therefore XYZ Bank cannot recover anything from Sabu. Number 3, No, as it was a wagering contract. And number 4, bank can recover money from Sabu so the payment of prize money can be made to Randeep. The correct answer option is A. It is a collateral agreement. A wager would be giving rupees 40,000 to Randeep if he had won the race. However, here it is established that Randeep is the winner already. Hence, it is not a wagering agreement, only a collateral. The next question. Principle. Sale of liquor is illegal. All agreements relating to prohibited items do not exist in the eyes of law. Facts. A entered into an agreement with B for the sale of liquor. A failed to supply the agreed quantity of liquor to B. The answer options are number 1, B can bring legal action against A. Number 2, A can bring legal action against B. Option 3, B cannot bring any legal action against A. And number 4, A and B can initiate appropriate legal proceedings against each other. The correct answer choice is option 3. This must seem easy after the discussion of concepts. The agreement for sale of liquor is prohibited. Hence, the agreement does not exist in the eyes of law. Therefore, no legal action can be brought by any of the parties against each other, including B or A. The next question. Principle. An agreement without free consent can only be enforced at the option of the party whose consent was not free. Facts. A obtains the consent of B to enter into an agreement by putting a gun on the head of B's girlfriend. Answer options. Number 1, B can enforce the agreement. Number 2, B cannot enforce the agreement. Number 3, A nor B can enforce the agreement. And number 4, B can enforce the agreement. Number 4 is A can enforce the agreement. Explanation. The correct option is option 1. Clearly, the consent of B is not free as his girlfriend has been put under threat. Therefore, as B's consent was not free, it remains in the hands of B to enforce the contract. The next question. Principle. A condition to a contract can also be complied with after the happening of the event to which such a condition is attached. Facts. A promises to pay 5,000 rupees to B on the condition that he shall marry with the consent of C, D and E. B marries without the consent of C, D and E but obtains their consent after the marriage. The answer options are number 1, B's marriage is not valid. Number 2, B has not fulfilled the condition. Number 3, the condition is illegal. And number 4, B has fulfilled the condition. The correct answer option is 4. The easiest way to look at this is what is the condition. The condition is that the marriage should be consented to by C, D and E. What is the present state? The present state is that the marriage is consented to by C, D and E. Hence, the condition is fulfilled. Now, the consent has been obtained after, but the principle clearly sets out that the condition can be fulfilled after the event. Note that the condition itself does not mention that prior consent needs to be obtained. Now we move on to the next question. Principle. Law never enforces an impossible promise. Facts. A made a promise to B to discover treasure by magic. The answer options are number 1, law will not enforce the promise. Number 2, law will enforce the promise. Number 3, law will enforce the promise only at the option of A. And number 4, law will enforce the promise only at the option of B. The correct option is 1. Impossible object of contract makes it void and therefore not enforceable. The principle states also that no impossible promise can be enforced by law. Discovering treasure by magic is an impossible task. Moving on to ILEAT 2016 questions. ILEAT 2016 question requires you to select option A if both A and R are true and R is the correct explanation of A. To select option B if both A and R are true but R is not the true explanation of A. Option C if A is true but R is false. And option D if A is false but R is true. The assertion or A is the parties to the contract must be competent to contract, otherwise it will be a void contract. The reason or R is all wagering agreements are void. The correct answer option is B. This means that while both A and R are true, R is not the correct explanation of A. We know that the content discussed that Both the assertion and the reason are true. However, they have no relation to each other and definitely do not share the relationship of an assertion and reasoning. A correct reason for the assertion could be that the parties who are incompetent to contract are incapable of giving valid, free and lawful consent. Therefore, such a contract against parties could never be enforced. Thank you for watching this video. For more resources, follow, like and share our page Law School 101 on Facebook. Also, subscribe to our main YouTube channel by the same name. We encourage you to post your doubts, queries, questions in the comment section below. These will be replied to within reasonable time. Best of luck, law aspirants!